Betul. Good afternoon, everyone. We will be starting the event shortly. For those who have just joined, kindly make sure that your microphone is muted throughout the session unless you are invited to speak. We also kindly ask everyone to remain until the end of the session as we will have a Q&A session followed by a group photo. Thank you and hope you enjoy the
Good
lecture.
afternoon, everyone. We will be
Good
starting the
afternoon,
event
Dr. Amy.
shortly. How are
For
you
those who have
today?
just joined, kindly make sure that your microphone is muted throughout the session unless you are invited to speak. We also
Hi,
kindly
good
ask everyone
afternoon,
to remain until the
or
end of
good
the
morning
session
from
as we
Scotland.
will have.
Um, it's really lovely to
Recording
be
in
here.
progress.
Oh, what time is it in Scotland right now, Dr. Amy?
It is 9 o'clock in the morning.
Oh, it's 3 p.m. in Jakarta.
Ah, okay. So you guys are getting ready to go and party for the weekend.
Yeah. First of all, allow me to introduce myself, Dr. Amy. My name is Steven, and I will be the Master of Ceremony for today's session.
Oh, lovely, lovely to meet you, Stephen.
Yeah, lovely to meet you too, Dr. Amy. It's a pleasure to meet you.
No, likewise. And I've never been to Indonesia, but I hope to visit someday. I hear it's a very beautiful country.
It is a very beautiful country, Dr. Amy, especially Bali, if you know Bali.
Yes, yes.
Yeah, you should visit Jakarta one day.
Yeah. No, it looks lovely, and I hear very nice reports from my colleagues, especially about the weather, because in Scotland, it must be said, our weather is pretty terrible. So
Oh, really?
yeah,
Oh,
it rains constantly every day of the year.
oh, it rains every day. Oh, in Jakarta, it's actually quite hot right now.
Yeah,
Because
I
it's summer,
bet.
right?
Yeah. No, we don't really get much of a summer. It's just like an extended winter.
Oh yeah. Oh, we don't have winter here. Yeah, that's why Indonesian people usually go to Europe for winter because they want to experience snow, right? Because we don't have any snow
Right.
here.
I see. That makes a lot of sense. Yeah.
Yeah. Well, we will start the lecture in a few minutes, okay?
Okay, perfect. And I should be able to like share my screen and show slides and things like that.
Yes, of course, of course. But we will
Perfect.
have a welcoming speech first later.
Okay, great. Thank you.
Good afternoon, distinguished guests, lecturers, and fellow students. Welcome to today's guest lecture entitled Copyright, Contract, and Video Games, Terms of Play in Comparative Perspective. It is a great pleasure to have all of you here with us today. My name is Stephen Lee, and I will be your Master of Ceremony for today's event. Before we begin, allow me to acknowledge and welcome our distinguished guests. First, we are honored to have Dr. Ade Atari SH MH as the head of the Master of Notarial Law Study Program. And of course, we are pleased to welcome our distinguished guest speaker, Dr. Amy Thomas, a senior lecturer in intellectual property and information law at the University of Glasgow School of Law. Dr. Thomas's academic work focuses on intellectual property and information law, with particular interest in copyright, digital environments, and video games. She has also conducted research on topics including video games user-generated content, esports, copyright, and the contractual terms that govern players' experiences. Her recent work is especially relevant to today's discussion, as her book Copyright, Contract, and Video Games Term of Play explores the legal terms governing players and the relationship between copyright and contractual arrangement in the video game industry. Without further ado, it is my pleasure to invite Dr. Ade Atari SH MH as the head of the Master of Notarial Law Study Program to deliver the opening speech. Pak Ade, the floor is yours.
Thank you, Stephen. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. The esteemed speaker, Dr. Ami Thomas, welcome to Universitas Tarumanagara, and also my dear students. Good day, everyone. On behalf of the Faculty of Law, Universitas Tarumanagara, it is my great honor to welcome you to this international guest lecture. We are truly grateful to our distinguished speaker, Dr. Ami Thomas from the University of Glasgow School of Law, for sharing the expertise with us. Today's discussion on copyright, contract, and our video games, distinguished speaker of Dr. Ami in comparative perspective from University and of Glasgow for this moment. School of Law. Looking ahead, we sincerely hope that this webinar will not only enrich our knowledge, but also serve as a foundation for closer academic collaboration between Universitas Tarumanagara and the University of Glasgow. We believe such cooperation will strengthen our shared commitment to advancing legal education and also research on both national and international level. Once again, I extend my heartfelt appreciation to Dr. Ami Thomas, our esteemed speakers, and to all participants. May today's session to be fruitful, inspiring, and also step forward in fostering stronger international partnership between UNTAR and University of Glasgow. Thank you so much, Stephen.
Thank you very much, Pak Ade, for the opening remarks. We will now proceed to the main session of today's event. Ladies and gentlemen, video games are no longer simply a form of entertainment. They have developed into complex digital environment involving creators, players, platform, intellectual property rights, and contractual relationship. Yet, when we start a game, we often encounter pages of terms and conditions or end-user license agreements that we simply accept before we can begin playing. This raises important legal questions. What exactly are players agreeing to? How do copyright and contract interact in governing the experience of playing video games? And do these legal arrangements operate differently across jurisdictions? These are some of the fascinating questions that will be explored in today's lecture. We are therefore very fortunate to have Dr. Amy Thomas with us to discuss copyright, contract, and video games, terms of play in comparative perspective. Dr. Thomas, thank you very much for joining us today. We are very pleased to have you here. The floor is yours, Dr. Thomas.
Thank you so much for that lovely introduction, especially to Stephen and Addy as well. This was lovely. I'm just going to start sharing my screen, if that's okay, just so you can see some slides I've prepared for the session. Can everyone see that okay? I hope so.
Yes, we can see your share screen, Dr.
Oh,
Tom.
lovely. Thank you very much, Stephen. So yes, hello, Indonesia. I hope everyone is very well, and thank you so much for having me to speak with you today at the University of Tarumanagara. And thank you for joining. As I mentioned to Stephen before the call started, my students at this time in a Friday afternoon would normally be checking out for the weekend to go and party or get up to some shenanigans. So thank you for your attendance. I do appreciate it. So as I've already been kindly introduced, instead I will just thank Stephen as the Master of Ceremonies for such a lovely introduction, and also Dr. Addy as well for kindly inviting me to speak with you after seeing the publication of my book, Copyright, Contract and Video Games, which was recently published by Hart Bloomsbury. And those three things, so copyright, contract, and video games, are a really accurate summary of my research interests. And so today I'll talk a little bit about these areas with the idea that you can learn some more about how games are distributed in a global, often digital market, and some of the legal challenges that we might encounter here. I understand that most of you will be interested in business law, so I'm going to try and make this as applicable to your studies as possible by detailing some of the commercial realities of legal work in the video game industry. And Dr. Addy also gave me the additional challenge of situating this research in a comparative perspective, which is new for me. And again, I hope will make this research more relevant for you. My plan for structuring this talk is that in the first half, I'll tell you a little bit about the background to the research and what I've done to date. And then in the second half, we'll look more at the comparative or international aspect. I also understand that not everyone here will have a background in intellectual property or copyright. So I've tried to pitch this with that in mind, and you're certainly not expected to have any prior knowledge of the topic. And who knows, maybe I will persuade you to be a copyright lawyer in the future. So I plan to speak for around an hour or just underneath that. And then I understand there'll be time for questions and answers. So please do bring your good questions forward. I'll also say though, if something is not clear while I'm speaking, or if I am not being clear, then feel free to raise your hand or put something in the chat. I know especially that I have a very strong Scottish accent, and I will not be offended if you need me to repeat something or slow down for when I'm speaking, because I get excited when I'm talking about my research. So with that in mind, I will start us off. So why video games? I don't think all of you will be interested in copyright or contracts, but I bet a lot of you are interested in video games, and I am too. I study games, but I also play them both for science and for pleasure. So right now I am playing Fields of Mystria, which is kind of a farming simulation game, and I'm also playing Balatro, which is like the card game poker, but much more fun. So there's many reasons this is an interesting creative industry to study. First, if we look at this economically, it's the largest entertainment industry in the whole world. It's bigger than the scale of music and film and television combined. So this is enormous, and it also tells us that if you're planning to work in a business that deals with creative industries, you're very likely to encounter video games at some point. Technologically, games are also interesting. They experiment with lots of new technologies. They innovate in things like graphics and virtual reality and artificial intelligence, which is obviously a very hot topic at the moment. Games are often now published by some of the biggest tech companies in the world. So we have Microsoft that publishes Xbox games and designs Xbox consoles. We also have Amazon trying to get into the gaming market. And also because there's very low barriers to entry to publish these games, in theory, anyone can make a game and publish it on Steam, even if you're just one person designing a game in your bedroom in your spare time. So there's also lots of these smaller independent game companies too. And Indonesia is actually great for these kinds of smaller, innovative games that tend to be more experimental with different genres and ways of playing. So my favourites from Indonesia are Coral Island by Stairway Games, which is a little bit like Fields of Mystria, which I mentioned before, a sort of farming simulation game, and also Coffee Talk by Toga Productions, which is more of a kind of visual novel. These are both great if anyone needs recommendations. We also have with video games that their business models are very diverse. So games are published in a variety of ways, increasingly digital rather than physical. We'll download our games via a kind of dedicated marketplace rather than going out and buying a disc. And now we also have the prospect of cloud gaming, where a bit like you access Spotify for music or Netflix for film or TV, now you can pay a monthly subscription fee to access a library of games. So Game Pass by Xbox would be a good example of this. So overall, we have lots of innovation, lots of big, powerful companies and an industry that is at a massive scale, and that's all interesting in itself. But on the other side, where I'm more interested, we also have communities of players. So people like me that are deeply engaged in these little subcultures around games. My colleagues and I think that there's a sort of particular quality to players where they are very passionate. And this passion might arise in part because, unlike other forms of media, games aren't just passively consumed, they're actively interactive. You have to actually invest time and labor to develop certain skills to progress through a game in a way that you don't necessarily need to with, say, a film, for example. There's also increasingly these player communities that do more than just play, but actively create new things using game content. Oh, sorry. Thought I'd do something there. Oh. Oh, thank you. So we have these player communities that do more than play and actively create things using game content. So the most well-known of this would be game streaming or pre-recorded so-called Let's Plays, where people film themselves playing games. And that can be a very lucrative career for a very lucky few. So some of you might have heard of PewDiePie, for example, who was ranked as the highest earning YouTube creator for years. So not just gaming YouTuber, but any YouTuber. He earned up to 15 million US dollars a year from the platform, mostly from playing games. There might also be some Indonesian gamer stars as well that you're more familiar with, of course. And this is quite interesting because we have a player base that on the one hand is quite consumptive. We can be very lazy when we're playing games if we're on our couch on a Friday night. But they're also inherently interactive and skills-based, and they can earn people a lot of money. So we have a good reason to anticipate that people are interested in using and consuming content made by players themselves quite separately from the companies that actually made the game in the first place. So for the remainder of the lecture, I would quite like you to put yourself in the shoes of the player if you aren't already. So think of your favourite game and how important it is to you and what you'd like to be able to do with it, whether that's now or in the future. So now copyright, the copyright question. Why is copyright relevant to our understanding of video games and what does it mean for us as players? So we confront copyright every day, even if you aren't necessarily aware of it. When we interact with pretty much anything in the digital world, including games, we are also implicating copyright. And that's because copyright and other types of intellectual property are what protect, broadly construed, so-called works of creativity. So in games, that may include a lot of things. There might be copyright in the underlying code of a game itself, so the literal written instructions that say this character will jump when the X button is pushed, or that might say, generate this number of trees in this particular forest map. There'll be copyright in the visual aspects of the game as well, so the graphics, the actual appearance of those characters or items. And there'll be copyright in the music and audio too. So that includes things like the soundtrack to a game or the voice acting by characters in a game. And these different aspects might also be made by hundreds of different people, especially for bigger game developments. So for example, lots of software developers might work together to write the code, and graphic artists might design the characters, or voice actors might give voice to the characters that are in the game. But this whole bundle of rights is usually all owned by one entity, which is typically the game publisher, and that usually that's at a company. Some well-known examples of this would be big companies like Microsoft or Nintendo or Tencent. In Indonesia, we also mentioned Toge Productions and Stairway Games. These are owners of game rights. Now, because companies own these copyrights, the law gives them certain powers to control how a game is distributed and used. So it can control, for example, whether a game company wants to sell the game in certain countries and not others, or to set a price at which they're happy for the game to be accessed. Importantly, though, as I mentioned here at the bottom of the slide, copyright isn't what we would consider an absolute right. So that means there's lots of instances where people are allowed to use a game without paying or asking permission from the game company if there are specific carve-outs in the law that allow this. These are usually referred to as exceptions. So for example, in the UK, we have an exception that allows us to make criticisms and reviews using copyrighted works, and this wouldn't be considered an infringement. And I'm sure in Indonesia there'll be similar provisions for this. These exceptions are really important limitations to the scope of copyright because from a policy perspective, copyright law is trying to find a balance between the private interests of a rights holder who might, for example, have interest in controlling how a game is distributed in order to recoup some investment or pay their employees. But we're also interested in the rights of the players who might want to use a game for socially or culturally or economically beneficial reasons. So if I want to film myself playing a game and upload it to YouTube because, for example, I want to illustrate that the game is maybe not of good quality and warn others not to buy it, this could be seen as an important social activity that the law would want to permit. And then the third part of contract. Where does contract come into all this? Well, copyright is useful for granting those initial rights that give powers to control certain activities with a game, but it's not super helpful for the specifics. So if you want to say your access to this game is conditional on you paying us every month, then you have to actually write that into something, and that's where contracts come in. So these days, when we talk about contracts between a game company and a player, we're typically talking about things like terms and conditions, user policies, or end user licensing agreements. These are typically the very long, very boring, and often impenetrably written policies that you have to check that you agree to when you play or install a game. We sometimes call these click wrap licenses because by clicking them, you are showing that you assent to the terms. I'm willing to bet that most of you won't have ever read these, but don't worry, that's not a barrier to understanding this today. So the terms in these contracts might be closely related to copyright. So for example, as I mentioned before, they might state that there's a price on which the use of the game is conditional, or they might say something like, you are not allowed to copy this game onto another device. So they're literally controlling that right they have to prevent copying. Or the terms might look nothing like copyright at all and say something like, you are not allowed to cheat in this game, and we will use our power as the rights holder to prevent you from accessing it if you are cheating. So contract can actually be a very flexible tool for rights holders, and it's now something that you will systematically encounter when you are playing a game. So from a business perspective, this means you can control what happens with both the copy of the game itself, but also what happens within the game space. And that could be really important for controlling things like harmful or offensive behavior, especially in a multiplayer game. So even while the idea of copyright, which protects something sort of more neutral, the act of copying or distributing or communicating a game in some way, even though that's quite different from harmful or offensive behaviour, the two can merge through contract. But there are a few problematic things about these contracts which you might already be aware of. And the first, as I alluded to, is that they have very low readership. There's a really important study that I can send a link to if it's helpful that claims the biggest lie on the internet is that I have read and agree to the terms and conditions. And indeed, the most kind of recent statistics on this vary between 91 to 99% of people not reading those terms when they agree to them. So we don't necessarily know what's in there as players. Part of the reason we don't want to read them is because they're very long. Many terms and conditions kind of exceed the word count of huge works of literature. So Apple's terms and conditions are longer than Shakespeare's Macbeth, for example. And they're also written in a way that's very dense and technical. And we as lawyers might be able to understand some of those words, but not necessarily all of it. And certainly most lay people who are not educated in the law will struggle to engage with this because it's written like a legal contract. They'll include fancy terms like represent and warrant, heretofore, prima facie. This is sometimes referred to as legalese. It's like its own little language. So these contracts, very long, boring, difficult to understand. We don't want to read them. We want to play the game. And that means we might miss how some of the terms in these contracts are very problematic. They might be actually extremely unfair to the player. As one of the fun examples, Game Station, which is a UK-based game retailer, got 88% of people visiting their store to agree to a clause that transferred the customer's immortal soul to their ownership. So 88% of people have transferred their soul to Game Station. And now, when I gave earlier the example that I might want to make a criticism or review of a poorly made game to warn other people not to buy it, what if I agreed to a clause in one of those contracts that said, I agreed not to make any such criticisms or reviews? Or if the company said that I wasn't allowed to speak in a way that was disparaging of their product. And what if I did read it, but I didn't understand what it said because it was very vague or very legal and technical? If I'm not allowed to make copies for a game for any reason whatsoever, does that extend to me making copies of the game being played for the purposes of criticism and review, for example? Now, in practice, some of these terms have been litigated, and often their enforceability is 50-50, it's middling. Sometimes courts think the restrictions are reasonable and sometimes not. So I'm going to give you a couple of case examples just to show how this has happened in reality. The first case here, Bragg versus Linden Labs. was a case in the US about the game Second Life, which feels fairly ancient now. But Second Life is an online multiplayer game where you can essentially create your own virtual world and have your own virtual assets. So different items or even currency. So Bragg, the plaintiff in this case, his account for Second Life was terminated because he was accused of fraud and hacking within the game. And as a result of his account being terminated, he lost all of his virtual world that he'd built and all of the in-game currency that he'd acquired over the years. And that was quite substantial. That was about 8,000 US dollars worth. So Linden Labs, the defendants here, the makers of Second Life, tried to get the case dismissed because they argued that Bragg had agreed to a mandatory arbitration clause in the game's terms and conditions and that he wasn't allowed to bring the case to court effectively. But the court has said, actually, the way the contract is sort of constructed here, the fact that when we agree to these terms, they are not negotiable, we can't go to the game company and ask them to change it. And also because they're sort of agree or walk away, then this was effectively a very unfair clause and it was considered unconscionable, meaning that it was effectively unenforceable. As a result, this was then settled outside of court, and Mr. Bragg eventually got his entire Second Life world and currency reinstated. So from this, we might think that contracts are quite weak, and part of that reason is because of their format, that they are non-negotiable. They are agree or walk away. But then I'd like to share a more recent case from the UK, which concerns the game Grand Theft Auto 5. Some of us who are game fans might have watched the Grand Theft Auto 6 trailer last night, like me, at midnight. So this case was about the plaintiff, James, was brought to court because he was accused of creating a cheat software for the multiplayer version of Grand Theft Auto 5. And that cheat essentially allowed people to endlessly create new weapons and cars and currency in the game. And so it sort of undermined the principle of fair play, especially as other players who were not cheating would have to pay for such items with real money. In this case, the court considered that there was a provision in the terms and conditions which James agreed to, where he had said that he would not cheat and would not interfere with the security of the game server. And this clause was held to be enforceable, and Mr. James was liable. So quite different from the Second Life case. And what we're left with is a very mixed picture of whether game companies can rely on these contracts or not. Sometimes they're effective, sometimes they're not. Consider also that in both of these cases, we're both talking about essentially cheating or unfair advantage in games, but they led us to different conclusions. Someone drafting a contract for a game company would be rightly unsure as to whether this clause would be upheld if it was disputed in court. There are, of course, cases from different jurisdictions, but the principles of contract shared between the UK and US are actually quite similar in this regard, yet they reach different conclusions. So much of my research to date has essentially been about, well, if these contracts are so legally tenuous, why are they still relied on and systematically used for distributing games? My hypothesis has always been that we can actually read these contracts almost more like a story, like a novel. It's really more of a story about what a game company does or doesn't want from us as players in an ideal world. The phrasing of this is quite deliberate because, as I mentioned, we know we don't read these. So it's not likely that we are deeply influenced in behaving in the way that a game company says, except maybe when a rights holder chooses to enforce a consequence and kick us out of a game. Instead, I think contracts are interesting as a window into telling us more about the priorities of the game company? What does an ideal world look like for a game rights holder? How would we as players behave in order to achieve this ideal? What are their commercial priorities? Which is to say that even if these clauses aren't necessarily enforceable, it's also interesting that they exist in the first place, right? Arguably, in some cases, it's more risky to have a certain clause than to not have a certain clause. So if you consider the expense that Linden Labs must have incurred to try and defend their arbitration clause, for example, it would have been arguably much better for them not to have it in the first place. So to date, when I've been studying this, I've employed an empirical method to try and understand the intentions of the company writing these contracts, to understand what does the ideal player look like. This was my doctoral research, and some of you here might be PhDs, in which case I wish you good luck and good fortunes in your studies. So during my PhD, I compiled a database of game contracts, and I gathered all the terms for 30 different popular video games. Because of the way the terms are structured, they could apply to all games held by a particular rights holder. So I estimated that this was around maybe 1,500 games in total that these terms applied to. And I also found that these terms live across many documents, not just one discrete set of terms and conditions, but actually lots of different policies that regulate the same game. So again, while I looked at 30 game titles, that made for 70 total documents. So it's a very complex network of different contracts that all rely on each other to sort of express this intent. And again, I'll share with you briefly some of my key findings to date, just to give a flavour of the key issues we might expect taking us into our comparative perspective. The first thing is that these contracts vary wildly depending on whether they're written by a big corporate company versus a smaller indie company. I found that big corporate companies like Microsoft or Amazon, Tencent, Activision, all of these companies take a very heavy-handed approach to the law, and they are written in a way that is very serious and conservative, and how we would expect a traditional legal contract to be written. On the other hand, smaller independent companies tend to be much less legally orientated. Their contracts are written much more informally, almost in a friendly way. So they use language that's not legal or technical. They might say things like, "Thank you so much for buying our game. Here's some rules we would like you to follow. Please don't be unkind to anyone you meet in the online game." Things like that. The second finding is that one of the most important restrictions that game companies want to set, regardless if they're written by a big or a small company, is to control how the copy of a game is distributed, and in particular to stop people from reselling games. This also applies to things within a game, so any virtual property that you might buy, like an outfit or a weapon or in-game currency. This is also described in contracts as being stuff that is not owned by you, even if you think you might have bought it. You might recall that the Linden Labs case was precisely about this, so clearly we haven't learned not to have this clause in there. And finally, I found that these contracts try to regulate those creative player activities that we also mentioned at the start, so people who stream games on online platforms and such like. These aspects of the contract are actually very permissive in a way that I wasn't expecting. They really want people to reuse game content and share it with the world. They might even let people in some cases make money from doing this. So for example, a lot of game companies are very permissive about monetizing game streams and making it eligible for things like ad revenue or donations. Or letting you request money if you want to sell fan art of a game character. A lot of the time, the conditions attached to player creativity are more about the kind of quality of the behaviour shown by the player. So, for example, if the player says something offensive on a game stream, the rights holder wants to retain the discretion to request that it is removed from a platform, for example. So with that, as a summary of what I've done so far, I have not yet considered to date the comparative perspective, and I thank you now for the opportunity to do so. For my own part, I think it's important to be really transparent about where my expertise lies, and I certainly wouldn't want to be talking to the future brilliant minds of Indonesian law about Indonesian law, which I know nothing about, but will be curious in the Q&A section to hear about your own experiences and reflections on this. In terms of jurisdictions I am familiar with, I am trained in UK law. But even within that, there are some nuances across different jurisdictions. So I am in Scotland. It has some different rules about contracts, for example, from England. The UK in turn gets a lot of influence from the European Union. And even though I'm sure most of you will be aware that we have since withdrawn from the European Union, we still have a lot of what's called retained or assimilated law. So we have a little bit of influence still from European Union regulations. I also teach on some US law. So I know enough to be dangerous, but I would not consider myself to be an expert there. I am also not an expert on comparative methodologies, which are very particular and require specific approaches and expertise. And again, I want to be transparent about that. I don't think it would be helpful for me to compare different jurisdictions like apples and oranges, saying that they're sort of different, but so what? Instead, for my part, I think for the comparative perspective, I can offer reflections on how there is a story here about how games are moved from one jurisdiction to another using contracts and the legal challenges that might arise here, especially as when we are increasingly in a digital world where things might happen instantaneously and are globally available, jurisdiction can start to feel quite invisible. For me, from an intellectual property perspective, I tend to see people and institutions rather than places that a company owns a thing, and forgetting sometimes that companies are ultimately domiciled somewhere, that their legal, cultural, and social influences will affect how they manage their property, and it will ultimately be bounded by a jurisdiction. Or that a server for a game ultimately lives somewhere physically in a room somewhere, and it doesn't actually just ambiently exist in the stratosphere. So where would we look in the world if we were wanting to see which jurisdictions to focus on for this study of player contracts? History in some ways is a good indicator. In the very early days of video games, the US seems to be the kind of progenitor. In the late 60s and early 70s, there were college campus labs full of people developing little prototype games, not in any way conceived for mass consumption, but they set a lot of early norms around how games were distributed and used, and we would expect them to be established in the United States. But then through the 80s and 90s, Japan especially starts to come into the games market and even to dominate it a little bit, both in terms of game software and hardware. So Japan has Nintendo, which makes its own consoles and games, and likewise with Sega and Sony in respect of the PlayStation. So at a time when games are becoming more common in the home, we then might expect Japan to have set particular standards for how they are used and played. And now today, we see from the wee chart on the slides that the United States and Japan still feature highly, but China is actually also a very big market. So that would be very relevant to look to. We also see South Korea and Germany, strongly represented. That's especially with regards to esports, where people play games competitively and professionally. The UK is also up there, more as a consumer than a producer, but we do have some noteworthy developers. So right now, for example, Rockstar North in my country will be busy finalising aspects of Grand Theft Auto 6. So these are some of the jurisdictions where you might be interested in looking at if you're interested in studying games, which is not to say that other jurisdictions are not equally as interesting or as important, but simply to highlight where we might expect to see an issue, for example, litigated or frequently transacted with from a business perspective. I am certainly not going to attempt to rigorously look at them all today, nor would I be qualified to do so. But instead, I'm going to look at the broader cross-jurisdictional differences that we see with player contracts themselves and look at some of the legal issues that they might cause. As a first step, we'd have to consider first where we might actually expect laws to differ substantially, such that we would expect a different result if these contracts were actually litigated. Copyright is largely harmonised at international level. The main international instrument that ensures this is the Berne Convention, which sets some minimal rules about what copyright must protect and various limits to copyright. Most countries in the world are party to this. I think only about maybe 20 are not. So we have some assurance that as a baseline, copyright might be quite similar across the globe. There are still some meaningful differences in copyright law, where the Berne Convention leaves discretion for member states to implement it in different ways. So, for example, Berne essentially has a test that says there should be limits to copyright that let people reuse works so long as it doesn't prejudice the legitimate interests of the creator. But what that looks like specifically can vary from state to state. So, for example, in the UK, we have exceptions for particular uses like criticism and review. In the US, for example, they have the fair use system, which you might be more familiar with. Then contract by contract is not internationally harmonised at all. So we might expect it to be very different in different countries. Some things that are enforceable here might not be enforceable in Indonesia. Some formalities of what a binding contract looks like will be very different. Even certain words or terms might not have equivalents in certain jurisdictions. So while we can be assured that copyright will have certain key features in all Berne countries, we don't know what contract looks like. And most importantly, there is no general doctrine in the Berne Convention about what to do when these things are different. So the puzzle that I posed earlier, what if copyright law in the UK lets me make a criticism and review of a game, but a contract prohibits it? What we tend to find is that in countries with a very strong freedom of contract ethos, like the UK and the US and Hong Kong as well, contract usually prevails, even if copyright says differently. You might recall as well the case I mentioned earlier about the Grand Theft Auto 5 cheats, so Take-Two versus James. This is a good example of the contract copyright dilemma. So there's no rules in copyright that define what cheating in a game looks like. There is no cheat concept in copyright. In that case, the court actually said that even though in theory the cheat involves copyright infringement because you're literally copying in-game assets and duplicating them, it doesn't matter that this is copyright infringement as much as it matters that the contract prohibits the notion of cheating. So here they didn't even explore the copyright question because the contract was perceived as more important. Whereas we might find that in countries that have stronger notions of things like user rights and consumer protection, for example, that they would more likely favour copyright law over contract. One case that maybe highlights this is from the European Union, which does tend to have a more kind of pro-consumer orientation. So this case is Usedsoft versus Oracle, where Usedsoft were seeking to sell second-hand software. So for example, if you had an old copy of Photoshop or Microsoft Word that you didn't want to use anymore, you could upload it to the Usedsoft market and resell it and get some money back. Oracle are the rights holders of some of this software, and they had clauses in their contracts which prohibited the resale of software when it was bought, much like what our game companies do based on my research as well. But here the court took a very principled approach and essentially said, we will treat this no differently than we would with physical works. If someone has sold a copy of a book, then we would accept that the rights holder has no interest in the distribution of that particular copy anymore, and therefore we can give it away, or we can lend it to a friend, or we can resell it online. So the court said the same should be the case with software, and that particular clause shouldn't be enforceable because copyright has limits on the distribution of works for precisely these reasons, that we should be free to get rid of old copies of things we don't want anymore, and maybe to get some money back from our losses. So these are some of the legal issues we might expect looking at this question of game contracts comparatively, differences between freedom of contract countries versus more kind of pro-consumer user rights countries. I'm now going to highlight a couple of clauses where I think the comparative aspect is most interesting. So the typical rule about cross-border copyright enforcement is that you look into where the infringing activity took place to decide where it should be litigated and under what rules. So if I wanted to dispute the legality of a no criticisms and review clause, then if that was distributed to me in the UK, I should take it to a national court here, notwithstanding the fact that the game company might be based in Japan, for example. The Berne Convention mandates this sort of mutual reciprocity, so rights holders can be assured that their rights will be respected here, the same as if they were a creator in their own country. However, most of the contracts that I reviewed for my empirical research were by game companies based in the United States. And systematically, they tended to include a clause which sets the choice of law through which the contract will be governed. And for player contracts, that's almost always the law of a district in California or New York in the United States. In some ways, this makes sense for game companies which tend to be based in, for example, Silicon Valley, which means it's very convenient for them to litigate there with laws and judges that often favour, for example, technological innovations. They might perhaps be more likely to look favourably upon a game company if there is a dispute. But what this also means is that contracts are almost always written from a sort of presumed United States perspective, using US legal assumptions and concepts that don't necessarily translate to other jurisdictions. To be doubly sure of this, I did use a VPN to check whether if I accessed the contract from a different jurisdiction, did the contract change to take account of any differences of the laws in the country in which the game was being distributed? But the answer is no. They all broadly stayed the same. The only slight differences I noted were where some contracts were distributed in the European Union, mostly to account for the European Union having quite specific policies and high standards around things like privacy or data protection, warranties or health and safety. Other than that, the default contract in the US version and that's implemented without alteration or customization, that is what we tend to see when we play a game. And the result is that we have this sort of homogenizing effect where US principles are normalized in contract because those are what we are encountering everywhere. Now, these choice of law clauses are typically enforceable, especially if there's a logical link between the choice of the jurisdiction and the activity. It would only typically be unenforceable if it was chosen to escape a very core legal principle of law in the locality where the contract's being distributed. So, say, for example, for you guys, the consumer law of Indonesia is much kinder than in the United States. A court in Indonesia could refuse to apply the choice of law clause. As an example, we might look at the potential conflict with rules around resale of games. So you might recall that most of the contracts I encounter say you're not allowed to resell your game, but in general, that's allowed in the European Union with some nuance. But in the US, this is categorically not the case. It's prohibited under copyright law to resell digitally distributed copyrighted works. So if there's a clause in a contract governed by US law that says you are not allowed to resell your game, but you are in the European Union where you think you're entitled to do so, would this be considered a kind of fundamental conflict that would set aside the provision of the EU rules? I'm really not sure. And then we might look at further questions like if the clause is not enforceable and you are legally allowed to resell your game, what if you receive a digital copy of a game via a very closed platform system? So, for example, if you own a games console, or even if you download games on your mobile phone, you've bought them from an integrated digital marketplace. And there isn't necessarily a technical mechanism that enables you to actually remove the game from your device and resell it in a country where this is allowed. This is a debate that's actively being discussed at the moment, especially as Sony, so the creators of PlayStation, they've announced that their next console will no longer have any physical discs, meaning that players will be entirely reliant on these closed digital marketplaces. And so there's definitely a nexus here between contract, technology, and law, which is interesting to explore in a comparative context. Here it's also maybe worth highlighting the role of the platform itself. So my suggestion that, Sony as creators of the game hardware might influence how game software is produced and used. This might be important, if not more important, than the choice of law in a game software contract. So, for example, Sony and Valve have their own contracts which say if you buy a game using their consoles or marketplaces, that if there's a conflict between the platform's terms and the game company's terms, then the platform's terms should prevail. On the other hand, Microsoft and Apple have terms that say the game company's terms are what stands if there's a conflict. So depending which platform you access a game might actually impact which terms you are governed by, which in turn might put you in a completely different jurisdictional light. So there's lots of layers here. One unexpected area where this might also cause a conflict from a comparative perspective is with user-generated content, or UGC. This is the legal term we've given to the types of player creativity we've referenced today, making game streams and Let's Plays, for example. In copyright, the legal status of user-generated content is a very complex question. It's an excellent dissertation question as well if you're looking for ideas for this. So you'll recall that copyright is meant to protect people's creative work. So certainly that includes people who create games or aspects of games. And likewise, some people might argue that the act of playing a game is also creative because the player has to make choices about how they progress through the game, how they style their avatar, for example, or make a particularly effective attack combination. In some jurisdictions, that could mean the player themselves has a copyright in their act of playing a game. So potentially that means that the person who plays a game and streams themselves doing so could also have rights, and that could empower them, for example. So if you say, I have rights in my stream of a game and I upload it to YouTube, then a game company wouldn't have power to request a takedown request because I have my own rights. So this is a really important question for copyright purposes. Are players actually creators? So again, with reference to our choice of law provisions, we'll mainly be looking at this legal question of who owns user-generated content through the lens of US law. And in the US, they are very clear. There's a lot of case law about this that essentially says, no, user-generated content like this is not creative. Their reasoning is that because all the player is doing is setting rules by the game maker, they have too limited permutations to make something creative. A player might have the impression that they're doing something and have autonomy and choice in how they progress through a game, but actually all the possible permutations of how a game can be played are predetermined, and the player is just making choices within a finite set of rules. As a result, everything, all these kind of streams and let's plays and other types of user-generated content are considered in the US derivative works, which means they are all owned by the game company, and all these rights sort of flow upward. Other jurisdictions, of course, might disagree or conceptualize user-generated content differently. So in Canada, for example, there is a specific user-generated content exception, a bit like the exception we mentioned earlier for criticism and review. This one says user-generated content is not an infringing activity as long as you're not using it commercially and it's not having a substantive adverse effect, financial or otherwise, on the primary game. That's a kind of clear conflict of assumptions that are made in the contracts written from a US perspective. Don't know if I've managed to draw something on these slides by accident. I do apologise. But you'll also recall one of my key findings from the empirical research on these player contracts is that they're actually, in any case, very permissive about people making user-generated content. So notwithstanding the fact that these contracts are written from a jurisdiction that has a very restrictive view of giving players rights in their streams and their let's plays, contracts nonetheless say, hey, it's fine, we're giving you permission to do this, please go ahead and make these things. And you might also recall that these contracts also sometimes say that it's okay for you to make money from these types of user-generated content, again with some conditions, but broadly letting you monetize content on online platforms. These contracts have a role in saying that this is okay. Now, from a marketing perspective, if you're a game company, it's a great way to get positive exposure of your game to millions of people by having people play it and show people on streaming platforms how fun it is. And we might see too that there's little risk of any kind of market substitution here. The game company is making the game, but they're not filming themselves playing it usually. These have different functions from a consumer perspective. The experience of watching someone play a game is very different from playing it. But again, this contractual position presents a conflict from our comparative perspective. So first, if you consider jurisdictions where there is, for example, an existing user-generated content exception like in Canada, there's clearly a conflict between the legal exception which says these activities can't be commercial and the contract which says that you're allowed to make money from your content. In practice, I don't think this will be much of a problem because the legal basis for the activity has sort of transformed. We're no longer relying on default law, but the permissions that have been given through contract. And recall for the most part that we are operating on assumptions of freedom of contract and, provisions we discussed previously. The second issue is thornier and maybe a bit more conceptual. So what if in some countries the creator of user-generated content would be considered an author? In the US, this isn't the case, but some countries like Germany have previously accepted that people who play games might also own rights in that footage. This would turn a lot of the assumptions made in the contract on their head. Permission from the game company wouldn't be needed in the first place to make this content because under a legal paradigm where the player has rights, this would be an entirely autonomous activity. Likewise, any other restrictions that might be put on making that user-generated content, like a game company saying it can't contain offensive language or certain footage from a game, like spoilers, wouldn't be valid because, again, we're talking about a new autonomous copyright figure rather than a sort of allowance to infringe, which is how these activities are currently conceptualized in contract. So again, cross-jurisdictionally, the treatment of user-generated content in game contracts can prevent some tricky issues. This is the last comparative aspect I wanted to bring to your attention, which I call, with the utmost respect and love, the strange case of Japan. So recall that we said that the US is the most prevalent choice of law for most game companies when enforcing their player contracts. That is true, but it's not the exclusive choice, and the second most represented jurisdiction in my data set has been Japan. That might make sense because, as we mentioned earlier, historically, Japan has been very entrenched in the video game market, especially since the 80s and 90s. Now, with game companies based in Japan, I have found that they are consistently much more conservative and restrictive with what they allow players to do. That's both in terms of the more consumptive things they might want to do with a game, so lend it to a friend or resell it or make a backup copy, for example, as well as the more creative things they might do, so for example, making the game streams. Japanese companies are, on the whole, from my research, very against all of these activities and are much more of an all rights reserved culture. In some contracts, I've seen they even equated things like reselling games as being the same as piracy, so putting a largely legal activity on equal footing with an activity that is clearly illegal. I was really confused by this finding at first because this very restrictive attitude seems to me at odds with what I know about Japan, which is that, for example, it's the home of a lot of fan culture and cosplay culture, for example. I would expect their attitude to the reuse of assets from a game to be much more permissive. So I did a wee bit of a deeper dive on the Japanese companies to try and understand where this attitude was coming from. And what I found that is that of all the companies I surveyed for this work, the Japanese companies are very old. So Namco and Bandai, now Bandai Namco, were established in 1955 and 1960 respectively. Bearing in mind that the first kind of commercial video game was made in 1972. This is very early. Konami was in 1969. Nintendo, my fun fact for the day, was established in 1889. So comparatively to many of the companies in the US, this is much, much earlier. Now, age alone doesn't tell us everything, but it does give us some indicators of why we might think about a conservative legal approach to managing game assets. First, probably because of the kind of front runner advantage, many Japanese companies have a huge establishment in brands. Some of the biggest media franchises in the world, let alone video game franchises, are based in Japan. I'm speaking here mainly about Pokemon, which is, I believe, still the biggest media franchise in the world, which is owned by Nintendo. Nintendo also have Mario, Legend of Zelda. Konami makes Metal Gear Solid and Silent Hill. Namco made Pac-Man, which is very iconic. Capcom has Street Fighter. These are all huge gaming brands. And the value of these assets for branding and merchandising is quite obviously enormous. But viewing these games more holistically from a broader intellectual property perspective rather than just copyright, I have the impression that the value of the property of the brand, which is almost more the trademark aspect of it, might mean that certain activities are approached differently. So there's a difference between, for example, someone drawing fan art of Pac-Man, which is heavily merchandised, versus fan art of a less established game character in the United States who is not merchandisable. This is, of course, a sweeping generalization and largely just my suspicions that someone should certainly research the Japanese attitude towards game regulation in the future. Again, a good dissertation question. The second observation I would make as well is that in Japan, because of how entrenched and important video game companies are to the economy, they tend to have more political power to influence the development of law. And this means that the more restrictive approach of the contract isn't necessarily in conflict with Japanese law, but it might actually be a reflection of it. So, for example, while we might find it strange that a player contract would forbid reselling or lending games to people, in Japan, there's actually some legal basis to this, and that's largely because of lobbying by the games industry. In 1990, for example, Nintendo managed to secure a de facto ban on game rentals because they were being blamed for declining revenues in the game industry. And I guess the reasoning is that if the product is being sold straight to home, any sale lost through renting would be a decline in revenue. I'm not entirely convinced about that reasoning, but again, more research would have to be done to confirm. So I'm going to just start wrapping up now by reflecting on this work and the path ahead. So we started today by discussing this sort of nexus between copyright and contract and sort of problematizing rather, the amount of power given by the law to set rules about how games are used. And especially we talked about the concept of freedom of contract and how this can be used to either modify or extend default rules of contract law in different ways. Sometimes more generous than copyright, sometimes more restrictive. Then we moved on to the comparative discussion, thinking about how these player contracts work in a global context. And when we moved to the international perspective, we noted that copyright is largely internationally harmonised, whereas contracts are very different at national level. And so while we can make some assumptions about baseline rules of copyright, wherever we might be, contract can be very different. However, then we've seen that player contracts systematically use these choices of law clauses to set the jurisdiction of governments to the US by default. And this in turn means that a lot of the legal concepts we encounter in these contracts are through a US lens, from a US point of view. And these might not always match the concepts we have in our own jurisdictions. And this is the kind of homogenizing effect. We looked, for example, at user-generated content, how this is conceptualized differently in the US than elsewhere in the world, and that it might embed some problematic, legally questionable assumptions about who owns and controls user-generated content. And then finally, we explored Japan as a bit of an oddity, one definitely worthy of further study, because there are some indications that it feels like a very different legal culture for the regulation of video games, which is facially more restrictive and conservative, but we would need to do more research to confirm that. So on that note, what does the future look like and what might be some interesting things to explore in the future? First, I think there might be important questions around the form of these contracts and how we expect to encounter and read them. This to me is really foundational to this discussion because we started by saying that we acknowledge that no one reads these things, that they are annoying, they're boring, they're very long and very technical. And in any case, they are non-negotiable. So if we don't like what we see, the only option we have is to not agree to it and not play the game. That is a problem in itself. If the form of the contract makes these problematic clauses quite invisible, then we can't challenge them if we don't know they're there. And especially where we know that there is a sort of encroachment of US law into other jurisdictions, there may be plenty of avenues for valid challenges to be had. The second question is more about the limits of freedom of contract and to what extent we as players might be due some kind of affirmative rights. This is a long-standing tension in copyright law, that in theory, creators have affirmative rights that can be enforced, whereas as players, we're only really entitled to exceptions to those rights, limited defences or shields, but not something that we could affirmatively take and say, hey, by restricting or limiting how I can use this game, you're actually infringing my own right. In some ways, this would cut through what we would call the Gordian knot of these tricky clauses, we suspect might not be enforceable in certain jurisdictions. We wouldn't need to assess whether something is unreasonable or unconscionable because we would know that we have a basic minimum level of right that would entitle us to certain things. That's maybe more of a kind of policy discussion, but I think it's a worthy one to question to what extent we let contract be enforceable to the degree it is. And then finally, I think more work could be done on the angle of technologies enforcing the terms that are set in these contracts. As I mentioned, the fact that consoles may now be designed in a way that actually at a technical level prevent you from doing certain things. This is much more different from an abstract contract which might or might not be enforced. We can't ignore if a console doesn't let us resell a game and we can't easily bypass it. Likewise, I now systematically encounter parts of games where my PlayStation will technically prevent me from streaming it because the game company usually doesn't want me sharing spoilers. So perhaps we need to extend the copyright and contracts discussion to also consider new technologies across jurisdictions. So with that, I'm going to conclude. I really want to thank you so much for your time today, and I really hope you found it interesting. If you're interested, please do consider reading some of my work. You might also be interested in following the work of my research centre, where we do lots of research on all sorts of creative industries. You can find us at create.ac.uk. And actually, starting this year, we at the University of Glasgow will also start offering a master's course about games and law. So anyone who's particularly interested in standing out in this industry can speak to us here. But for now, however, I will thank you again. And I do look forward to hearing any questions or reflections you might have on today's talk. And yes, thank you again for the opportunity to be here. I'll stop sharing my slides now.
Thank you very much, Dr. Thomas, for that insightful and engaging presentation. Ladies and gentlemen, we have now reached the Q&A session where we will have the opportunity to further explore some of the issues discussed during the lecture. For those who would like to ask a question, please raise your hand or use the designated Q&A or chat function. When you are invited to speak, kindly introduce yourself before asking your question. It seems like we have Charles Asuriadi. Please state your question.
All right. Hello, my name is Charles, and thank you for the presentation that you have given us, Professor. I want to ask about the legal status of music, especially licensed music, because if you've ever played a game like FC 26 or NBA 2K, you know how the soundtrack has music from other artists, like pop music, rap, rock, and those other kinds. And there's the weird thing where a person who wants to do a stream or a let's play in these games, they're not allowed to use these musics, even though they were licensed to the video game developer. So I want to ask, why is a streamer not allowed to use the music when he's playing the game, but the game itself is allowed to use the music?
Thank you so much, Charles. That's an excellent question. And I'm really glad that the music issue has been raised because it is treated as such a special and exceptional type of content in these contracts that I've read. So a lot of them, as you rightly say, that they will say you are allowed to stream this footage, but you might have to mute some of the music that is being shared within it, even if it is already embedded in the game, as you say, third-party songs that are maybe embedded in like a radio station or something like that. I'm thinking of Grand Theft Auto at the moment. And part of the reason for that is that I think that music companies in general are quite litigious when it comes to copyright, and it speaks to the fact that games, as a general rule, in most jurisdictions, are not considered a sort of standalone, cohesive work, but rather a patchwork of different bits of copyrighted aspects. So, as I mentioned earlier, software developers have interests in certain aspects, graphic artists have interests in certain aspects, music has interests in certain aspects. And a lot of the time, when these music companies are entering into agreements for their music to be used in the game, they do not give permission for it to be used in streams of the game, which is a very kind of important nuance. Um, I guess because the fear would be that I could technically say, okay, I'm going to stream this footage of me playing Grand Theft Auto with this song on in the background, which is included in the radio in the car that I'm driving in the game. And I could use that to substitute effectively the other video that's on YouTube that allows me to listen to the music, therefore diverting revenues from the person who made the music in the first place. So I can see the logic and why they do this, but it makes for a very strange player experience where you can't kind of share the whole way you are experiencing the game and listening to the music. So I think it's an excellent question, Charles, and I thank you for raising it.
Thank you very much, Professor.
Oh, great, thank you.
Next, we would like to invite Felicia Natania to ask their question to Dr. Thomas.
Okay. Hi, Dr. Amy. First of all, thank you for the wonderful presentation. My name is Felicia, and I'm sorry that I cannot turn on my camera now, but I do have a question. You mentioned about that copyright can protect artistic works in video games, which including the character voices. And as a video game enjoyer myself, I often came across people in the internet using artificial intelligence to copy or to replicate those voices for other purposes. So in that case, I was wondering if that would be considered as copyright infringement, and if it's yes, who usually owns the rights to the character voice? Is it the game developer or the voice actor? Thank you.
Wow, that's a fantastic question, Felicia. Thank you very much for raising it. And I was wondering if we would get questions about AI because I know it's a very hot topic at the moment, and I will do my best to answer this. But in some ways, I think we could almost have another lecture about this precise topic. So essentially, the concern is that voice actors for video game characters might have their performances copied and repurposed through AI to essentially emulate them in a way that sounds like the character but isn't the original performance. It's the kind of deep fake problem of AI emulating something in a way that seems real but isn't, authentic to the person who performed it. And this is increasingly a policy issue. The answer is this is a great comparative, kind of context for this question because the answer really does depend on where you are in the world. From a copyright perspective, there's actually almost two different rights at play here. So there's the right and the underlying performance that a voice actor is giving. Usually, if a voice actor is in a contract with the games company to provide that character voice, they will give their rights to the company and just essentially sign them away and say, I give you permission to use this, and I agree that in return I will be paid some money for it, and that'll be that. What that means now is that the game company owns the underlying performance in that voice acting, and they also own the recording of it that's been taken. So there's kind of two different layers of rights. So as a result, the game company owns those rights in that voice acting performance, and they can give it away. So if a game company chooses to get into a contract with a generative AI company, they could say, take all this data from our voice actors and use it and that would be entirely lawful. But in some countries, and maybe in Indonesia, there is such a thing as image rights, which is more about protecting the sort of persona or more ephemeral qualities of a person, so the way that their voice sounds or the way that they look. And that can apply quite separately from copyright or performance rights. In that case, if you're in a country that has a strong image right culture, then you could complain on the grounds of image rights rather than copyright, because in copyright it's not going to help you. You'll have signed most of your rights away. So, for example, in the UK, we don't have image rights. So there's nothing unlawful about making a deep fake AI voice actor, for example, which leaves that we're actively considering changing our law because of this, because it is a little bit unfair to performers who are quite vulnerable to having their voices replicated without their consent. But as I say, in other countries, perhaps in Indonesia, you might have an image right that would actually protect you in this case. I hope that answers your question, Felicia. Oh, she's got a crash. Oh, okay. Oh, thank you for letting me know.
Thank you, Felicia and Nathania, for your question. And thank you, Dr. Thomas, as well. And now I would like to invite Brian to ask their question to Dr. Thomas.
Good evening, Dr. Amy. First of all, thank you so much for your very insightful presentation about copyright games and etc. But I would ask a question about, I would like to raise awareness about the recent cases about PlayStation, maybe around 5 months ago, about the DRM, the digital right management that require the console to be authenticated to us with a server to the thing remain to the game remain playable. Because I own a PlayStation myself, and I quite scared on what that rule gonna be about. But my question is, does the end user license agreement clause that legally downgrades a game purchase into a revocable license that can be revoked anytime they want violate customer protection laws regarding product transparency? That should be my question, Mr.
That's, again, a great question, Brian. You have all come with great questions today. I really appreciate it. I also own a PlayStation. I also share your frustrations around digital rights management and constant server verification, especially for online games. And I think that your question speaks to two recent sort of controversies in the industry, one of which was the proposal for PlayStation to remove all physical discs, meaning that online games will be the new norm and things like server dependencies will become much more prevalent. And also perhaps the Stop Killing Games political movement. They're a kind of cohort of people that are specifically complaining about the issue you raised, that with some games, if they are dependent on an external server owned by a company who is no longer interested in maintaining that game, if they close that server, you no longer have access to your game. And you're right, this has been asked in more of a kind of consumer protection, customer protection line of query. I specifically think that's because copyright here at least is working as designed. If you look at these contracts, they technically are framed as a revocable license. They've sold you this on the assumption that it can be taken back at any time. I can't speak for every country, at least in the UK. I have indication, like, I think that our courts are starting to become a bit more sympathetic to this idea that companies in this case are essentially mis-selling their product, right? They say that you've bought it, that you've downloaded it, that you own it forever, when in reality what you've been given is a conditional revocable license that can be taken away, as you say, at any time. In the UK, we had a case recently about a very old game called RuneScape, which some of you might or might not know about. And that game was about whether or rather that case was about whether someone had hacked into another person's account and had stolen lots of virtual currency and virtual items, so things that don't exist in real life but clearly have a kind of monetary value. And the court had to consider whether this was the concept of property, whether they had bought or sold and owned things in the game, notwithstanding the fact that the contract says you don't own any of this effectively. And the court in that case says, actually, we do consider this as property that you own and that you should be entitled to recompense for if it's been stolen, because it functions like property. You can buy it and you can sell it and it has value, and only you can own it at the time that you possess it. So I think, at least in that sense, I mean, that's a criminal case, obviously, not a civil case, but it suggests to me that courts are becoming a bit more sceptical about this language that says you don't own something, when for all intents and purposes it seems like you do. And I'd like to think that that will be extended to the concept of a game and what kind of remedies you're entitled to if it is no longer supported and is removed from your system, because it is misleading. So it's more of a hope for the future, I think, Brian, than any concrete legal advice at this point, but I hope that gives you a bit of a steer.
Okay, thank you for the insightful answer, Dr. Amy.
Thank you.
Thank you so much for your question, and thank you once again, Dr. Thomas, for answering the question. And now I would like to invite the next turn to ask their question to Dr. Thomas.
Okay, let me just lower my hands for a sec. Okay, so first of all, I would like to say thank you so much, Dr. Amy, for providing us with this delightful topics to begin. Because first of all, a profound gamer myself, and since I am also profound in the way of looking at the gaming community, I also look myself in some of the come across this news about GTA 6 leaks. This something about it that I think I found interesting is a way of how this so-called cyber leak, also known as the agents that are trying to leak some sources just so that the Rockstar company could provide them with more sources. Now, here's the thing that I would like to ask. So where does this copyright law draws the line between a fair use commentary on leaked video game footage and also this illegal distribution of trade secrets? Because as you may know, these kinds of leaks sure have created these chains that created this audience that are somewhat disappointed, or maybe some of them are just like, hey, you can do that because Rockstar company had made them like a whole year from 2013 into 2026. So yeah, I usually just want to ask, like, how far can we set the line between copyright law? Because there are some people that are wanting to talk about it, a commentary, but there are some people that think that this is supposedly being labeled as dangerous stuff to watch because they're afraid they might like privacy or the safety of how the game goes. I think that's what I asked. Thank you.
That's an excellent question, Stern. I hadn't thought about the GTA 6 leaks in that context, but you're absolutely right. It implicates a few of these questions. I'll try and tackle this one legal issue at a time. Because first there might be the question of, does underlying copyright actually subsist in that footage because it's unpublished footage, right? So it's not actually been disclosed to the public yet. And my instinct would be yes, that's absolutely protected at the point that it's created. Copyright doesn't have any kind of formalities that mean that you would have to register it or publish it in some way for it to be effective. So it's certainly copyright protected. Then there's the question that you raised of fair use or the kind of copyright exception. So is it okay to use this footage, notwithstanding the fact that it's been illegally sort of disclosed, for the purposes of criticism and review? So say, for example, I was saying this footage looks really disappointing, the game is not finished, it's of poor quality, or something along those lines. So in principle, yes, there's lots of, as I say, there's lots of exceptions in copyright law that let you use this footage regardless of how it's been acquired. but it's certainly a common factor in tests for things like certainly fair use in the US and fair dealing in the UK. One of the kind of factors a court will consider is how was this acquired? And was it acquired through illegal means? And that can sort of weigh against a decision for fair use or fair dealing. It's not the only factor though. So for example, if I did a really in-depth critical analysis showing that this game was broken and that it was going to be a huge consumer issue if it was released like this, the court might still find in my favour, notwithstanding the fact that it was leaked illegally, and that is a factor against it. This is the thing with like fair use and fair dealing, is it's often quite unpredictable because it's all like different weighing factors that may weigh more than each other. But then there's the additional layer. I like that you mentioned trade secrets on top of this, because my initial instinct when I seen these leaks was that the copyright question we might not even get that far with this, because I suspect, so I have a husband who actually used to work on developing Grand Theft Auto, so I kind of know what he agreed to when he did that, is that he signed a lot of contracts about trade secrets and non-disclosure agreements that basically said, if you talk about this for anywhere outside of this office, we will go straight to court and, you will be sued. So they had a lot of contractual provisions in place to sort of say you are not allowed to share this content, even if it is for the purposes of criticism and review or something like that. There's also, at least in the UK, we have a remedy for breach of confidence as well, which in this case it almost certainly would be a breach of confidence where there is a kind of commercially valuable trade secret, as you say, that has been disclosed without permission, and probably because it has, and even after being specifically told not to disclose it. To me, this would be a slam dunk breach of confidence, breach of contract case, whereas the copyright question might actually be a bit more amenable. It might be like, actually, this is okay. But breach of confidence would kind of usurp that because it would remove the content anyway if a case was successful with that. So yeah, thank you, Stern. That was a great question.
All right, thank you so much again, Dr. Semi. It's
Thank you.
quite a very great answer to
Oh, good.
think about it. All right,
Good.
thank you so much,
Thank
Dr. Semi,
you.
and thanks again for the presentation.
Oh, lovely.
Thank you so much for the question, and thank you so much, Dr. Thomas, for answering the question. And
Oh, sorry, Stephen. I think I've lost your audio. Oh dear. Perhaps he will join us soon.
hello, sorry.
Oh,
We would like to invite Vicky to ask the last question due to time constraint.
Am I audible?
yep, I can hear you.
Okay. Thank you, Dr. Amy, for the chance. Recently, there are arguments regarding emulation and copyright. Emulation requires a game to be archived and accessible for free, and some people argue that it's a necessary evil to preserve games so that they don't become lost media when companies stop selling them digitally, and availability for people who don't own certain consoles, while several companies think it's a form of piracy. So what do you think about it? Thank you.
Yeah, that's again another great question, Vicky. And it's something that I am planning to study a lot more coming into this year, is the issue, as you say, of game preservation. Again, there's a few layers here. One of the issues is that games are, because of the duration of copyright, almost all games will be protected by copyright law still. It's not the same as with, I guess, a very old book or a very old film where the copyright interest might have expired. Here we're still looking at potentially having to preserve and put into museums and things games that are still protected by copyright. which means that we're relying on essentially, again, an exception to the law to enable us to do this. Again, I can only really speak for the UK perspective. We have some exceptions, for example, that would essentially allow a museum to take like an old game and preserve it and put it on a shelf so that if a researcher wanted to come and study it, they could, in theory, access it. But you, as a member of the public who maybe just wants to play the game because you remember playing it fondly, or you want to experience the way that your parents or something played the game, you wouldn't necessarily be allowed to play it. So it's a very limited exception. It means you can only use those games in a way that's not really useful for sort of socially or culturally beneficial access to a game. And that is an active legal issue that's being discussed just now. There was a report by the Video Game History Foundation that I think found that something like 89% of kind of older vintage retro games are no longer available on the market. So we're potentially looking at losing a lot of games if we don't have a more meaningful way of preserving them soon. And as you rightly say, there are a lot of communities that have taken it upon themselves, notwithstanding the fact that it could potentially be copyright infringement, to preserve these games. It really depends on the rights holder whether this is sort of acted upon by not. I know from speaking to some game developers that a lot of them are very grateful that these games have been preserved because they have not they don't have the resources necessarily to be able to do it themselves. Maybe they've not actually got a lot of the original files anymore, which, given some of the disorganisation in the early video game industry, is very, very plausible. So some of them are very grateful, but then also some of them are very litigious. So if you think of, I guess, okay, one of the first games I ever played was Pokemon Red, the original, which I think was like 1996 that it came out. That game cannot be bought through Nintendo anymore, but Nintendo might have a lot of commercial interests in re-releasing versions of Pokemon or vintage versions of Pokemon in a new market. So it's not the original game, it's an updated version, it's remastered, the graphics might look better or whatever. That to me is not the same product as the original. If I, as a researcher, or even if I, as a person wanting to experience it the way I experienced it as a child, I would need to have access to the original. But Nintendo in these cases has been very litigious about emulators precisely for this reason, because they don't want to lose the re-release, remaster market. So right now, there's definitely a lot of, I think it's true that video games are not being preserved adequately and we're losing access to that aspect of our cultural heritage, that copyright is definitely a barrier to it in terms of meaningful access to that heritage, and that right now it really depends on the rights holder whether it is acted upon or not. So again, it's a multi-layered question, and also a fabulous dissertation question if anyone needs ideas. But yeah, I hope that answers your question, Fiki.
All right. Thank you, Doctor. Yeah, it's very understandable. Thank you.
Oh, good.
One-
Thank you.
Thank you so much for the question. And thank you so much once again to Dr. Thomas for answering all the questions. And with that, this brings us to the end of today's lecture. And on behalf of the Faculty of Law of the Universitas Tarumanagara, we would like to express our sincere gratitude to
Recording stopped.
Dr. Amy Thomas for creating their time to have
Recording
this
in
lecture for the
progress.
Faculty of Law of the Universitas Tarumanagara. And before we officially conclude this meeting, we would like to have a documentation, and I would like to invite Charis to help with the documentation.
I will take over from here and lead the documentation process. Okay. Okay, so for the first slide, 1, 2, 3. Second slide, 1, 2, 3.
Oh,
Okay. The documentation session is concluded. Thank you for your cooperation, and thank you for Dr. Amy for today's fruitful session. Thank you, Dr. Amy.
Thank you all so much. I hope you have a lovely Friday night. Thank you for joining. This was a really nice experience.
Okay, thank you.
Thank
Now,
you.
now
Thank you so
everyone
much, ma'am.
now everyone may leave the meeting room and see you in the next session. Goodbye.
Thank you,
Bye.
Dr. Amy.
Thank you.
Thank you very much,
Thank
Doctor.
Thank you,
you.
Dr. Amy. Thank you, Dr. Amy.
Thank you very much.
Thank you very much.
Thank you.
Thank you.
Thank you.
Record.